Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Morning, Counsel.
Good morning, Judge.
What brings you here this morning?
I'm covering for Charles Hemming for Capital One versus Willie Collins. I'm covering for defendant Willie Collins.
Okay. I don't have Ms. Dillo as of yet. When I get you out of the waiting room and we'll get started on your file.
Sounds good. Thank you, sir.
Hello?
Hi, can you see me?
Yes, I can see you. What is your name, ma'am?
Crystal Klein.
All right.
Yeah.
Okay. Hang on for just a second. I think I may have your opponent here. Mr. Best.
Good morning, Your Honor.
Morning. What file brings you here today?
I have Capital One Bank versus Willie Collins. I show it's up for a final pretrial as well as a motion for summary disposition.
Okay, I'll hang on to you. Ms. Klein, I'm going to put you back in the waiting room.
Okay.
Don't go away. I should be with you soon. Mr. Kazmarek is here on that one, I believe. All right, gentlemen. We are on the record calling 22-191-792 Capital One Bank versus Willie Collins. Date and time for what is scheduled as a final settlement conference. Your appearances.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of plaintiff Capital One Bank.
And Jace Kazmarek, I'm covering for Charles Hemming for defendant Willie Collins.
Your bar number.
65461.
Gentlemen, are we settled?
I do not show that we have had any significant settlement discussions, Your Honor.
Okay, this case is here today. I inherited this file, but it's up to date for final settlement conference. And I note that a motion for summary disposition has been timely filed on behalf of the plaintiff in the matter. You gentlemen have not settled, so let's set your motion for summary disposition for hearing. The motion for summary disposition, gentlemen, will be heard March 6th at 10 o'clock. Does that work for everybody?
That works for plaintiff, Your Honor.
That's fine.
All right, gentlemen, I'll send out a notice today, March 6th, at 10 o'clock. We will hear plaintiff's motion for summary disposition. Anything else we can accomplish today?
Nothing from plaintiff.
Anything for you, sir?
Nothing, Judge. Thank you.
Let's be safe out there, gentlemen. Thanks for coming in. We're off.
Thank you, Judge.
You too. Have a good
See
day,
you, Dan.
everyone.
All right, y'all be good.
Hello.
Okay, we're about to start, Ms. Klein,
Okay.
soon as the other guy connects in. All
I
right,
was
we are on the record. This is file number 22-243-573. Crystal Klein versus USA Installation. Date and time for a motion for summary disposition on behalf of defendant. Could I have your appearances? Anybody gonna appear today?
I will, John Monick Jr. on behalf of defendant.
You remember the State Bar of Michigan?
I am
And you probably have a P number.
P55703.
What is your name, ma'am?
Crystal Klein.
Did you file an answer to the motion for summary disposition filed on behalf of the defendant USA Installation?
Did I file an answer?
To the motion for summary disposition. In essence, what their argument is that you have an agreement that any disputes are to be arbitrated, and yet you sued. Did you file an answer to that motion?
I didn't understand what that meant.
Okay, counsel, go ahead.
Yes, Your Honor, this is today's defendant's motion for motion to dismiss based on agreement to arbitrate the mandatory avenue for disputes per the contract. The terms and conditions of the contract are by arbitration, and it's for this reason that we submit that this claim is not to be heard by the court, instead to go into arbitration.
Yeah. Ms. Clark, is there anything you want to say about this?
Okay, well, they performed installation on parts that they did work that they weren't supposed to do.
Ma'am, I'm not arguing, I'm not talking about the merits of the case. His claim is that your contract provides specifically under terms and conditions, customer agrees that any dispute between customer and USA Installation will be resolved exclusively and finally by arbitration. Is there anything else
Okay.
you want to tell the court?
What does that
Disputes have
mean
to be
exactly?
arbitrated.
Huh? Okay, can you explain to me what does that mean exactly?
It means, ma'am, that you do not bring your disputes to a lawsuit. In a lawsuit, they have to be done in arbitration. All right, the court's had an opportunity to review this. The contract is unambiguous. There is no motion and no response filed. The case is dismissed without prejudice for the reason that the court lacks subject matter jurisdiction. The parties haven't agreed that any disputes shall be resolved exclusively and fully by arbitration. Ma'am, what you should do is look at your contract and take advantage of the terms of arbitration provided by your contract. You cannot bring that action in a court. It has to be according to your contract exclusively by arbitration. Court will send out an order to you both. Thank you both for coming in. We are off the record.
Thank you, Judge.
Have a good day, sir. Ms. Francis, good morning.
Good morning, Judge.
What brings you here today?
I have Universal Collection 431.
Okay, I do not have your opponent as of yet. Put you back in
Okay.
the waiting room.
Thank you.
Letty and Phil is starting all 3 days making a music show with Peter Tchaikovsky. This was show out of the end. Mozart's next. Stay with us here.
Support for WRCJ is provided by UMS, presenting Burnell Philharmonic. Dennis Russell Davies conducts a work by William Bunkum and music by Randall Spinachi, with vocal features that showcase the breadth of talent in our own community. Friday, February 10th in Hill Auditorium. Learn more at ums.org.
Mozart was 19 years old when he wrote this piano, number 6. This piano, he wrote for this guy named Baron von Dern, who commissioned the work from Mozart. And then, whenever they called him Diamond Dash Dern because he had to have it to do with this amount of completion. Services rendered. Here's Christoph Eschenbach when he looks at it. What we submit.
Ms. Francis,
Good morning again.
I have your opponent. As soon as she gets logged in, we can get started. Hello? Hello? All right, we're on the record now. We're on the record calling case number 22189-431, Universal Collections versus Brittany Tyner Ward. This is the date and time for a motion for summary disposition filed on behalf of the plaintiff. Notice of hearing today by notice dated January 9th, 2023. Your appearances.
Good morning, Your Honor. Najat Francis on behalf of plaintiff's attorney of record P72322.
And what is your name, ma'am?
Brittany Tyner Ward.
Ms. Ward, did you file an answer to the motion for summary disposition?
I believe I did.
When did you file it, ma'am?
Well, I think like a month ago or something like that. I'm not sure how the paperwork worked, but everything that the clerk told me I had to file and turn in from the paperwork that the collection sent me, I turned it all in. So
Okay.
I'm not sure exactly which was what.
All right, we're going to start, Ms. Francis, your motion.
Thank you, Your Honor. We did file our motion under MCR 2.1169 and C10, Your Honor. This was an assignment of a lease agreement that defendant had with TH Properties. Defendant has not provided any valid defense or and there aren't any issues of fact remaining for trial, Your Honor. So we are asking for our motion to be granted.
Ms. Tyner Ward, is there anything you want to say?
So I'm not sure exactly what she's talking about, but I know that I was never behind on my rent when I was in Terry's house. And we had an agreement when I moved out and everything. So the paperwork that was actually filed, that they filed against me them years ago, I never got it because they spelled my name wrong. So I never knew it was sent to me or gave to me because they sent it to the wrong person. I never knew nothing about the case until it just recently came to me last year.
All right. All right, court is prepared to rule this matter. This is a motion for summary disposition under MCR 2.116 C9 and C10. Because the plaintiff in their motion relies on matters other than the pleadings, the court will treat this as a C10 motion. A motion under subrule MCR 2.116 C10 claims that there's no genuine issue of material fact to be tried by the jury or finder of fact, and that the moving party is entitled to judgment as a matter of law. In finding the existence of a genuine issue of material fact, the court is required to be liberal in finding it and err on the side of the non-moving party. In this case, the plaintiff's motion for summary disposition was filed on behalf December 7, 2022. Since that time, no pleadings have been filed on behalf of the defendant. In their motion, plaintiffs rely upon, among other things, requests for admissions. Requests for admissions were served on the defendant and were not responded to. Under MCR under 3.212, those requests for admissions are therefore deemed to be admitted. Of particular relevance to the court in its decision today are requests for admissions numbers 3, the computations by which the principal balance due to plaintiff's instant civil matter was calculated are accurate. Request number 4, the balance sued for this action is due and owing by the defendant to the plaintiff based upon a pre-existing lease relationship between the parties as described in the aforesaid plaintiff's records. Number 6, defendant is not entitled to any credits set off except as those that have already been credited, deducted, etc. And more significantly, number 8, every statement or allegation contained in the plaintiff's complaint is true and correct. When a motion under MCR 2.116 C10 has been filed, court rule is quite specific. Court rule 2.116 G4 provides a motion under sub-rule C10 must specifically identify the issues as to which the moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. As the court indicated earlier, no answer has been filed for the motion for summary disposition. The defendant has failed to file an answer to the motion for summary disposition. Under the rules concerning the request for admissions, the relevant facts here have been admitted and are conclusively admitted for purposes of this litigation. Therefore, the unopposed motion filed on behalf of the plaintiff for summary disposition is granted. Ms. Ward, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Ms. Francis, I look forward to your order of judgment under the 7-day rule. Thank you both for coming in. We are off the record.
But can you excuse me, what did they say I didn't turn in? Because I turned in all the paperwork that the clerk
Ma'am, you
turned
didn't
in.
file an answer to the motion for summary disposition.
I did.
No, ma'am, you did not. Thank you for coming in. We're off the record. You may
Thank
have
you,
a
Anna.
day.
Isn't that Mozart wrote for Dine and Dash Journeys? They called him No Karen Baron. Because he didn't pay Mozart for the music that he would commission. You know, Sonata number 6. Yeah, here's the right. We just heard Christoph Eschenbach, Mozart, CJ. Richard Edgar at the Academy of Ancient Music, for record again. That's the Academy of Ancient Music, Richard Agar, and the event commissioner based by George Redmond, the WRCJ. As cold as it was at the end of this past week, to get into the 30s today, possibly 40. 90.9 that band, WRCJ. Support for WRCJ comes from Bank of Illinois. They can't help you keep smell it, but they can help you save for college. Bank of Illinois loves. Learn more at Bank of Illinois.
Yeah, right there.
Margaret Young, real estate to WRCJ, London Whitman, Akron, HD1, Detroit.
WRCJ is our two-way. Monday, Peter Burley, mental employee in this hour. Tim Kellington starts it soft with this funky sweet black brown beige 1940. We'll hear from the conductor, like I mentioned a few minutes ago, Buffalo Philharmonic, Joanne Quebec.
This is good. Basil. Burke. Patterson. Always in the car.
Yes, sir.
I hope you pulled over to the side, not moving.
I am parked and car is off.
Okay. I have Ms. Patterson. Mr. Randazzo is here. As soon as Ms. Patterson comes in, we'll get started.
Thank you.
All right, you can turn your video on, ma'am. We can get started. We are on the record. This is case number 21-167-134. Beaumont Health versus Monique Patterson. There are two matters before the court today. The matter that we'll take up first is a motion to withdraw as counsel filed on behalf of the counsel for defendant. Could I have your respective appearances?
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Daniel Randazzo, 39935, attorney for Monique Patterson. All right. Ms. Patterson, did you receive a copy of the motion to withdraw as your lawyer?
Yes.
Okay, do you have any objection to Mr. Randazzo withdrawing?
Judge, before we do that, I'm going to withdraw the motion. Mr. Burke and I and Ms. Patterson have come to an agreement, and we're going to be submitting a judgment in this case.
All right, tell me about it.
There's going to be a judgment entered for the amount of $3,836.78, for which Ms. Patterson is going to be making monthly payments of $50 a month until it is paid. At the time that the debt is extinguished, the plaintiff is going to file a motion to vacate the judgment.
Ms. Patterson, did you hear those terms?
Yes.
Do you agree to those terms?
Yes.
Mr. Burke, are those the parties agree? Did Mr. Randazzo accurately set forth the agreement of the parties?
He did, Your Honor. Thank you.
All right, this is what the court's going to do. I'm going to enter two separate orders. I'm going to enter an order withdrawing the defendant's counsel's motion to withdraw as counsel. I'm going to dismiss the matter without prejudice. Looking forward to your closing documents. Thank you all for coming in. We are off the record.
Your Honor, may I say one thing? I know you said we're off the record. It is a consent judgment. When you receive that, you will you sign that?
Yeah, what happens, Mr. Burke, is that I enter dismissal, indicate consent judgment to follow. when the consent comes in, then we move forward.
Thank you. Last question. Is there an email address for the court so that we can get it today? It has been signed by both parties.
Yeah, just look on the court's website. The email address is right there.
Okay,
Thanks, guys. Ma'am,
Thank you.
thanks for coming in. Let's be safe out there.
Thank you.
have a great day. Thank you.
Off the record. Drive safely, Mr. Burke. Mr. Stratton?
Good morning, Your Honor.
Hello,
Good morning. This is file number 22-178-276. Dearborn Total Automotive versus Olivia Martin, Richard Caldwell. Date and time for our 99th pretrial appearances.
Good morning, Your Honor. Trevor Stratton, P65124 for the plaintiff.
Leslie Cohn for the defendant.
For defendant Martin, correct?
Defendant Martin only.
Your bar number?
34889.
All right, my first question is, have we defaulted Mr. Caldwell?
Your Honor, I had indicated to you at the last pretrial that I had sent it in December, and I figured it just hadn't been processed. I still don't see it on the ROA, so I actually sent it in again the week before last. I don't see that one on there either. So I don't know what's happening with my paperwork. I don't know if there's a better way for me to get it to you, other than mailing it to the clerk.
Okay, I'll talk to you about that. Where are we on this,
Okay.
this other file, people?
Well, Your Honor, as you know, we've been dragging our feet, obviously, on this.
Yeah.
In regards to trying to get defendant 2 squared away. Your Honor, I know you probably want to dispose of this case. You know, I could file a motion for summary disposition and see how that goes. And, you know, in the meantime, obviously, Mr. Cohn and I could still try to resolve it. But if you want to get this case moving forward, that would probably be my next step on my end.
Mr. Cohn?
Why don't we dismiss Olivia Martin and allow the plaintiff lawyer to simply go after the more culpable defendant?
I don't think Mr. Stratton is interested in that.
Well,
No, and if
so-
Mr. Cohn wants to file a motion as to why that would be the proper ruling against Ms. Spartan, you know, obviously that's.
All right, well, let's do this. I'm going to give you guys one more pretrial. In the meantime, your next day with me will be March 6th at 11 o'clock. March 6th.
bear with me, Your Honor. March 6th
11 o'clock.
at 11 o'clock,
Yep.
Martin pretrial.
Okay. So I'm going to release Mr. Cohn. I'm going to put Mr. Stratton in a chat room and give him some information that I don't want to put on the internet that might help him get this document filed. March 6th, 11 o'clock, gentlemen.
Thank you very much.
Thank you, Judge.
Let's be safe.
Thank you, Your Honor.